On June 27th, 2018, the Supreme Court of the United States ruled on Janus versus AFSCME, American Federation of State, County, and Municipal Employees. This was a landmark labor law case concerning the power of labor unions to collect fees from non union members. Under the Taft Hartley Act of 1947, which applies to the private sector, union security agreements can be allowed by state law. In Janus versus AFSCME, a 5 to 4 Supreme Court majority ruled that such union fees in the public sector violate the First Amendment right to free speech, overturning the 1977 decision in Abood versus Detroit Board of Education that had previously allowed such fees. For more than 4 decades, the court has held it constitutional for unions to collect money from non members to support their cost of negotiating contracts on their behalf. Now that Janus overturned that precedent, employees can now enjoy the benefits of collecting bargaining without having to pay for it, and this will result in a substantial loss of revenue for labor unions. Justice Elena Kagan summarized her dissent with the following statement: "This is no sugarcoating today's opinion. The majority overthrows a decision entrenched in this nation's law and its economic life for over 40 years." I hold the position that collective bargaining practices, picket lines, work stoppages, and expansion of union control over schools are part of the American democratic system. I don't think the antagonists are really looking at the big picture. These systems of organization evolved from the framework the founding fathers put in place. In a capitalist society, workplace equality isn't guaranteed. It's one of the reasons our system of government is considered such an experiment. That's also why citizens need to be engaged and enable the democratic and constitutional systems that ensure that people are treated fairly through voting and using the third branch of our government, the judicial system, to remedy systems of inequality. I feel strongly that people and institutions that attempt to develop convincing arguments for having fewer advocates organizing labor that protect our natural rights, freedoms, and constitutional rights duplicitous. The right to have a good life and standard of living, and to pass the sense of worth and confidence you have of yourself, your students, and people in your daily life will improve outcomes. What this means for the education system is that teachers' unions could lose up to a third of their members nationally and funding as a result of the decision. It will hurt the national unions to provide crucial support for the local teachers' unions. This will weaken teachers' unions nationwide as a political force. This is some of the same money that has fueled walkouts and strikes. States with agency fees and public sector collective bargaining agreements tend to have higher teacher salaries and school funding than the 28 right to work states. The data shows that approximately 70% of the 38 million public school teachers nationwide belong to a union or professional association. I found a 2018 national survey that was conducted by Educators for Excellence of 1,000 public and charter school teachers, and it showed that most teachers believe working conditions would be worse without union representation. In conclusion, the necessary steps needed to improve the situation with trade unions could include a Bernie Sanders like plan that would create a European style system of collective bargaining where union leaders and managers would agree on minimum standards for an entire industry sector rather than negotiating separately with each individual company or school in the situation. This plan will repeal state right to work laws that prohibit mandatory union fees charged to non members to cover their share of collective bargaining costs and allow workers to form a union through a card check as an informal process that avoids a secret ballot election overseen by the National Labor Relations Board. As also, the Sanders Plan would ultimately allow the National Labor Relations Act, NLRA, of 1935 to be applied nationally to teachers and would provide even more collective bargaining power. This act would change the status of unions by recognizing that workers in private industry had the right to bargain collectively, However, originally it only applied to workers in the private sector and didn't cover employees of federal, state, or local government. So it didn't cover teachers because they're considered employees of the state.